now I give the floor to my colleague Bogdan. So he's a lecturer of constitutional law and European law at the Faculty of Political Science, University of Bucharest.
Now, unlike many of you, probably most of you, including our host, thank you, Yulia, I'm not an international public lawyer. I'm a comparative constitutional lawyer, and insofar as I'm interested in international public law, I am a neophyte to a certain extent, and I take a parochial view, meaning I'm interested in the way in which, say, domestic law, constitutional law, limits the operation of international public law. And what one can see recently under conditions of pluralism is that the meanings as such of domestic and international are shifting. For example, since the German Constitutional Court was mentioned as the most dualist of all constitutional courts in Europe, even the German court, which took a strongly dualist stance in its Lisbon decision of 2009 in reviewing the acts accompanying the ratification act of the Treaty of Lisbon, the two acts specified the rights of the Bundestag and the Bundesrat. Now, the Constitutional Court of Germany tried to limit the operation of international public law and to insulate the German constitutional system by specifying a certain constitutional core that cannot be encroached upon by international public law obligations. Why they did that? Because of Article 79, Section 3 of the German Basic Law, called the Eternity Clause. It specifies the certain values among which democracy cannot be alienated. Now, but in the decision, they refrained from enumerating. They specifically actually stated that the principle of sovereignty, which is entailed by the principle of democracy, which is protected by Article 79(3), does not mean that a certain number of sovereign rights or certain types of sovereign rights cannot be alienated. Why they didn't do that? Because from olden times, a characteristic mark of sovereignty, meaning the right to coin and establish the value of money, has already been devolved upon the Union, so you cannot establish a list. Instead of that, in the next paragraph, they said that the principle of sovereignty and thus democracy, guarantees of the basic law, imply only that there should be enough space for a political determination of economic, social, and cultural living conditions. But that is a vague formulation. And if we look at the present scope of the Union, we already see that we can find many examples in which the space has already been encroached upon. Now take only the European arrest warrant. Now, if we find such a difficulty at the national level of specifying what is the limit between domestic and international in respect to the conversation between a domestic constitutional court and the supranational organization as the Union, we can find the same problem at the supranational level. For example, in the two Cadi judgments of the Court of Justice of the European Union and the completely divergent motivations, reasonings of the two decisions of the Tribunal of First Instance, as it then was, now it's the General Court, and the ECJ respectively. To refresh your memory, although most of you, probably all of you, have read the two decisions, the problem dealt with a EU Council regulation that implemented a EU common position, that implemented a United Nations Security Council resolution under Chapter 7 of the Charter. And it dealt with the freezing of funds of specified individuals suspected of having ties with terrorists. Now, in 2005, the Tribunal of the Court of First Instance, the General Court, rendered a decision in which they said that the regulation could not be annulled. Why? Because the Charter obligation, so the UN system, prevails, is hierarchical and prevails upon the EU system. So we have a hierarchical position. And over the Charter, they said, prevail principles of peremptory norms, jus cogens, obligations, to which even the Security Council is subject. And since they didn't find any peremptory norm, any jus cogens obligation in that specific case with respect to the rights that had been alleged of being infringed, such as proportionality, right to property, right to a fair judge, they refused to annul the decision. Now, in 2008, the ECJ reversed the decision and annulled the regulation because from their perspective, the European Union as such is a constitutional system, is a domestic system, and international public law is external to it. So they annul the regulation based on fundamental rights protected under the EU system. And they stated the obligations, paragraph 285, the obligations imposed by an international agreement cannot have the effect of prejudicing the constitutional principles of the EC Treaty. Now, such problems will be compounded, I fear, in the future, especially as now you have two treaties that have to tackle the economic crisis, the ESM Treaty and the Fiscal Compact. And in the case of the Fiscal Compact, you have an international public law treaty that is not a part of the EU framework, that imposes constitutional level obligations on member states, namely the obligation to include in their constitution, to transpose in their constitutions the provisions of the treaty through norms of binding force and permanent character, preferably constitutional. And the fulfillment of this obligation would be adjudicated upon by the ECJ, but not the ECJ as a part of the EU system. The ECJ as a union institution that interprets the fulfillment of an international public law treaty that is taken upon by a member state at the constitutional level. Now, so one can see the problems at hand. What I'm getting at is that what seems to me interesting is that when we speak of international and domestic, we have to take care to observe the fact that the concepts as such, due to the shifting phenomena, have changed. So what is domestic and what is international depends to a large extent on reflexive perceptions of legal systems. So there is an element of reflexivity entailed by these transformations. Thank you very much.